This work is a part of a larger project called the Equality Project that's focused on Canadian youth and how Canadian youth from vulnerable communities are being set up for conflict and harassment online. And so there's a special focus on what we sometimes term cyber violence, or as I try more to call it now, technologically facilitated violence. I like to use that particular term because I think when we attach cyber to things like cyber violence, they tend to be easily dismissed as if somehow they're not actually happening in real life. So what we're looking at is really violence, in this case, violence against women and girls, and in particular the ways in which it's carried out through technological means. So our presentation will have three components. I'm going to tell you a bit about what led up to this study and results of a review of criminal cases that we conducted. I'm going to give you sorry, that's not the third thing. The third thing is an overview of the case law itself, and that'll be done by Professor Mathen. It's in my notes, yet not in the slide. So I'm going to start with number one. So on November 10th, 2015, Justice Goodman of the Ontario Superior Court of Justice acquitted Ryan Jarvis on one count of voyeurism, contrary to the criminal code. He was a teacher at Beale Secondary School in London, Ontario, and over a number of months in 2011, he used a pen cam to surreptitiously record multiple videos and images of students between 14 and 18, and a single video of a fellow teacher in hallways, classrooms, the school cafeteria, staff offices, and outside of the school in violation of school policy. His activities came to the attention of the principal when a fellow teacher reported having seen him using what he thought was a camera to record female students during track and field training as well as around the school. The reporting teacher said that occasionally he would jump in front of Jarvis when he saw the camera come out, and Jarvis would put the pen away. Shortly thereafter, the principal himself observed Jarvis talking to a female student while holding a pen in his hand that was emitting a red light. He later saw the action repeated in a lab where Jarvis was standing over top of a female student with the tip of his pen held over the top of his arm. When the principal approached Jarvis, he put the pen in his pocket, and the principal then escorted Jarvis into an empty room and asked to see the pen. Jarvis denied having it, but when the principal pointed out that it was just there in his pocket, Jarvis handed over the pen, and the principal in turn turned it over to the police. They discovered that the pen held 17 active videos that included 30 different individuals, 27 of whom were female students aged 14 to 18 at Beale Secondary. He tried to keep the pen cam out of evidence at the trial, but was unsuccessful on that motion. Eventually, the case was tried on an agreed statement of facts. At trial, the Crown submitted that the bulk of the images on the camera were generally pointed downwards towards the student's cleavage, that numerous video captures focused primarily on the student's breasts, and that in some clips the camera was actually set up only to capture students' breasts. When police requested access to his computer, he declined. A week later, when police arrived with a warrant, they seized several computers and an external hard drive, most of the files on which had been placed there the day after Jarvis had declined the police request to review his computer. While accepting that the students had a reasonable expectation of privacy, not to be video recorded without their consent, Justice Goodman concluded a critical element of the offence of voyeurism had not been made out. Specifically, he was not convinced beyond a reasonable doubt that Jarvis had taken the videos for a sexual purpose as required by the statute. Although the judge said he thought that it was most likely that Jarvis did have a sexual purpose, he reached this conclusion having regard for the fact that there was no other pornography found, that most clips included students' entire faces and bodies, that there was no nudity, no undressing or explicit sexual activity, and no direct evidence as to Jarvis's purposes, which obviously creates a problem in many cases because, of course, accused persons have a right not to testify. In light of this, all of this, though, the judge felt there may be other inferences to be drawn about Jarvis's sexual purpose, or his purpose in general. Thus, although the judge called Jarvis's behavior morally repugnant and professionally objectionable, he found him not guilty. On the day the verdict was released, one of the 14-year-old victims told a reporter that a 14-year-old girl shouldn't have to watch videos focused on her breasts. As she put it, you feel emotionally raped. The same day, the London Sexual Assault Centre posted this infographic on its website. Commenting on the case, the executive director of the centre said that Jarvis's actions violate sexual integrity, noting this is exactly why women don't come forward for the mere reason they're not believed, and we need to make a change. The community director of Western University Centre of Research and Education on Violence Against Women and Children said the decision exposes a failing in the legal system and society's inability to understand the harm done to women by such activities. She noted there's more than one way to violate personal space. Certainly, technology has given all of us new ways and means of violating personal space. So as a feminist researcher and lawyer working on the issues of online equality and cyber violence, this case, the Gomeshi trial, and myriad of others, caused me to ask what seems like an age-old question for feminist advocates, which is, can criminal law respond meaningfully to violence against women and girls? And how, if at all, does technology complicate answering that question? So, not being an expert in criminal law, I ran immediately to Carissima and convinced her to write a blog with me about Jarvis, talked her into collaborating on a paper where we're trying to sort out answers to these questions by studying the Canadian criminal case law relating to tech-facilitated violence against women and girls, the results of which I'm going to tell you about momentarily. But first, I have to add on that just a few weeks ago, the Ontario Court of Appeal issued its decision in Jarvis because the Crown appealed the acquittal. In a strange turn of events, the Court of Appeal upheld the acquittal, but it found Jarvis not guilty for reasons exactly opposite to those of the trial judge. First, the Court of Appeal said there was no other inference available on the record, but that the photos were taken for a sexual purpose. So they found that the trial judge had erred when he said he wasn't satisfied that Jarvis took the photos of students' breasts for a sexual purpose, according to as required by the code. If they had left it there, Jarvis would have been convicted, but the Court of Appeal went on to find that another required element of the offense had not been made out. Specifically, the court found the images were not recorded, or the images were recorded in circumstances that did not give rise to a reasonable expectation of privacy. According to the court, if a person is in a public place, fully clothed, and not engaged in toileting or sexual activity, they will normally not be in circumstances that give rise to a reasonable expectation of privacy. Although the court did say that if someone is on a public sidewalk with a tow camera, taking images underneath a woman's skirt, the circumstances do give rise to a reasonable expectation of privacy, presumably because what's under a woman's skirt is not otherwise visible to the public. One judge disagreed, noting that the result of that reasoning was the opposite of what one would imagine, namely that surreptitious visual recording of high school students for a sexual purpose while they are at high school is not illegal. In light of the Court of Appeal's decision, which, in respect of which a notice of appeal has been filed now with the Supreme Court of Canada by the Crown, Barbara McQuarrie, again the director for the Centre of Research and Education on Violence Against Women and Children at Western University, called the decision shocking and outrageous, declaring its open season on women's breasts, and hence the truncated title of our talk. Given that the majority decision would suggest that in public places, women have no right to privacy against someone photographing their breasts. This result, I just want to stop there for a minute just to think about that for a second. This result seems only to seal in even more the concern about whether criminal law can effectively respond to technologically facilitated violence against women and girls. And this is the concern that motivated Carissima and I to study the issue further, which then brings me to point number 2. Which is the results of the review of criminal cases. We work with a number of amazing research assistants whose names you see here, so shout out to all of them for their hard work reviewing at what at times were incredibly difficult materials to read. We reviewed reported Canadian criminal case law to unearth the ones in which technology, broadly defined, was used to perpetrate violence against women and girls, with a focus on cases over the past 5 to 10 years. Ultimately, we identified 113 cases, and the numbers are growing because we're continuing this in an online resource I'll talk about at the end. These cases involved 111 male accused and almost all female victims. A number involved boys as well, especially in the context of luring and child pornography. The accusations related to 13 different criminal code offenses, everything from harassment to sexual assault to non-consensual distribution of intimate images, defamatory libel, child pornography, and so forth. In these cases, there were 94 convictions, in all of which technology played some role in violence against women and girls, ranging from surreptitious filming with pen cams, video cams, smartphones, upskirt cams, to intimate images texted to friends and or posted on the internet, inviting male viewers to, as was done in one case, come on her pics. To doxing, which is the releasing of personal information online and sometimes inviting other men to the victim's home for sex. Swatting, phoning in fake 911 calls that in one case ended in the bomb squad visiting a victim's home. To persistent surveillance through multiple emails, texts, and tweets, and shadowing and posting on the hashtags the accused knew the victims followed, to accused trolling social media and gaming sites like Model Mayhem, Nexopia, Minecraft, Facebook, Plenty of Fish, to build trust with women and girls in order to later target them with online and or physical violence, including extorting nude images from them, to hacking email and social media accounts in order to impersonate children and then ask their friends for nude photos, to running websites like hotcams.com, which features underage girls performing sex acts, to the use of file sharing services like GigTribe, Imgur, and eDonkey to access and distribute nude images of underage girls. The case law really had it all, and with that review you'll understand what a tough job that my research assistants had, that our research assistants had in conducting this work. It is certainly not the kind of stuff that restores any faith in humanity that you may have had going into the exercise. Sitting back and looking specifically at the outcomes in the cases, there are sort of three broad things that struck us. First, a handful of cases were notably decontextual or perhaps even acontextual in terms of their analysis of harm and violence, and deciding whether they were present in the particular cases, and I'll come back to those in a minute. The second is an innocence narrative that was more likely to lead to presumed public harm where girls were victimized as compared to cases where women were victimized, and was reflected in a handful of cases in responsibilizing women for the harm that had been done to them. The third was obvious from the Jarvis decision and a series of decisions, in fact, relating to voyeurism, the insufficient provision of safeguards for women's right to privacy, in particular in public, especially thinking about what the Court of Appeal has now said in the Jarvis decisions, and its implication for women's bodily integrity, but I think its implications as well for privacy in public in general. I'm just going to focus my next few remarks on the first and second observations, decontextual analyses and the innocence narrative. Of these, Corby provides a classic example. It's a British Columbia case. In this case, the accused was acquitted of criminal harassment of his ex-partner after he followed her from Ontario to British Columbia after getting out of jail, told his new partner in British Columbia he wanted the victim to know he was in the vicinity, used his Facebook page to post photos of places frequented by the victim, including places near to where she worked, comments expressing longing for her, and a link to the Police song Every Breath You Take, about which the court wrote, "The pictures Mr. Corby posted were non-threatening and neutral in nature. Objectively, they were of a benign character, as were the comments about the complainant and the link to the song by the Police. It may well be that some of the images had a special meaning or significance to the complainant, subjectively viewed, whether because they were of businesses or places she visited or attended, or because they were of a location near her place of employment. However, none of these, either individually or collectively, were specifically directed to the complainant. Rather, they were placed on the accused Facebook for any Facebook user to view." Further, the court said, because the perpetrator had posted the material on Facebook, rather than sending it to the particular attention of the victim, it would seem there could not be any harassment until such time as the complainant decided to view it. And that step, they said, introduced an element of uncertainty to the completion of the offense, as it is outside of the control of the accused. Ultimately, the court determined that whether or not the complainant was harassed was thus dependent solely on her actions and not on the accused. So by taking each step of the harassment individually, the court misses the very real connection between online postings and the fear of physical encounters in real space that they can evoke. It's the seamless integration of the online and offline experience that's missing from this analysis. It also glosses over the fact that threats that may appear subtle, benign, or neutral to an outsider can quite reasonably carry very real and intended meaning to the person they are targeted at. Further, the court's approach suggests that only threats that are directly pushed to a victim, such as by email or text, will satisfy the intent element for criminal harassment. Since it noted the victim only received the information by pulling it toward herself, by signing in and viewing the perpetrator's Facebook profile. She did so using her sister's account, might I add. Taken to its logical extreme, this would mean that a wide variety of mechanisms by which women and girls are threatened online, blogs, social media sites, postings on message boards, seem to fall outside the criminal prohibition on harassment. A factor that I think was also present in a Twitter harassment case that was the subject of our review called R versus Elliott, which I'm happy to talk about later if people are interested. Further, I think suggesting to a target who tries to seek out information online to protect herself has somehow disadvantaged her in the context of prosecution is very problematic. Overall, all in our review, we tried to keep in mind the very real distinction, though, between a conviction and a survivor-centered outcome, as described by Larkham and Gotel in their writing. Sometimes, even though a conviction is achieved, even if a victim's evidence is actually accepted, she is re-victimized in the trial process itself and responsibilized for the violence visited upon her. Overall, I'd say from the reported cases that we reviewed, criminal law can respond to technologically facilitated violence against women and girls. But whether it will is actually a quite different story. I say this because a review of reported decisions presents a very rarefied picture of the willingness and capacity of the criminal justice system to respond. These are the cases that are handpicked to actually pursue charges, to actually go to court, to actually take to trial. They are an infinitesimal slice of technologically facilitated violence against women and girls as it is practiced in the world. And as many of you will know, most violence against women isn't even reported. And when it is, as Holly Johnson has shown, the report often isn't believed, and so in most cases, no charges are even laid, let alone the case going to trial and the decision actually being reported upon. That said, our review does suggest that the machinery is there. So if there's any suggestion that there are no criminal code provisions, technology has outstripped law can't keep pace, there may be some areas where adjustment is needed, but the fact of the matter is the fundamental machinery is there. in many of these cases, as you see from the 13 different criminal code offenses that are applicable to the many ways in which violence against women and girls is carried out. For that reason, we're suggesting that if there is an actual will to protect the sexual, emotional, and psychological integrity of women and girls, there is a way. And so I'm going to turn it over now to Professor Mathen to talk a bit about the meta-analysis of the case law.
Thanks very much. Thanks for coming, everyone. I know this is a very intense time of year, and it's really gratifying to see so many of you come out. So in this paper, as Jane Bailey has just described, we examine a number of criminal law provisions that to date have been used in Canada to prosecute cases of technologically facilitated violence against women and girls. As criminal offenses, the various provisions have different elements that must be proved beyond a reasonable doubt. The criminal law framework is quite properly a rigorous one. It's attended by several important procedural and substantive safeguards that are entirely appropriate given the serious consequences of a conviction. In a separate part of the paper, we shift from an operational to a more theoretical focus. We discuss the role and function of criminal law provisions used to address this type of predation. And we note that when dealing with an emergent social problem, as all of this has been over the last decade really, it's not always apparent whether and to what extent criminal sanctions are warranted. The answer to that question is important because it helps to rationalize the structure of the relevant offenses and to shape the decisions of criminal justice actors. We acknowledge that there is a risk in extrapolating too much from the reported cases. Not all criminal cases in Canada are publicly reported, and the incidents captured under the relevant offenses vary widely with respect to motivation, methods, circumstances, and consequences. That said, we've noted certain core unifying elements that, in our view, justify speaking of these offenses as a kind of class. We don't suggest that this is present in every single one of the reported cases. We don't suggest that these elements necessarily figure into the definition of the offenses by Parliament, but they do serve, we think, to characterize the various activities in an analytic sense and provide a way to understand them as criminal behavior. The first of those elements, of course, is the defendant's use of technology. That use may be at a fairly low level, such as using a device to record illicit images, or it may involve more complex leveraging of online tools, such as posting material to platforms like Facebook, where it is then distributed potentially to millions of other people. The internet's ever-increasing scope in all social relations and everyday life poses huge challenges to ensuring that any criminal law response is effective, just, and proportionate. Second, the technology is harnessed to capture or control personal information. In recent years, there's been a great deal of social attention on cases involving images, but other information that is specifically identifiable, such as phone numbers or personal or business addresses, may also be at play. The use of the technology is not uniform. In some cases, the accused will leverage it to actually create the information. In others, the information is manipulated by stealing, lying, or dissemination. And sometimes, of course, multiple uses and technologies are used. The third element is that the victim's will is overborne in a non-trivial way. Sometimes the victim is stripped of all agency by the defendant from the outset, such as when she is not involved in the initial decision to create the particular information, such as an intimate image. But also sometimes the images or information are initially shared or consented to, but then her consent is not considered by the defendant in later uses or manipulations. This absence of consent is very important to our analysis. A fourth element is what we call objectification, which is, of course, a term capable of multiple meanings. For example, it could mean the deliberate depiction of a particular individual as a quote-unquote sex object. That phenomenon is important as it can lead to great personal harm, but our use of objectification is not limited to that. Instead, it's meant to refer to a way in which the accused seizes something that is valuable and personal to the victim and turns it into a weapon against them. What is it that these activities take from the victim? We suggest that in many cases, it is her sexual integrity. We argue that this term is appropriate because of the undeniable sexualized aspect of many of the situations involving technologically facilitated violence. It's also appropriate because of the frequent undercurrent of sexual violence, for example, through communications that falsely depict the victim as being open to sex, and the frequent impact of such activities on the complainant's broader sexual reputation. Now, to be sure, this is a term that is not without risk. Sexual integrity could suggest a need to examine whether the accused's own motive is sexual in nature. In our opinion, that focus would inappropriately direct attention away from the accused's wrongdoing to a particular purpose that he may or may not have had. The term could further encourage investigations into the prior sexual persona of the complainant. That too would be a concern, since historically the criminal law has failed to prevent such investigations from becoming tainted by sexist myths and stereotypes. You could instead argue for a term such as emotional integrity or psychological integrity. Those come with their own problems, largely converging in concerns about overreach. Harming a person's emotional well-being without more is rarely considered a criminal act. The law often has nothing to say about much human behavior that reasonable people will consider morally reprehensible, but which society does not view as a kind of public harm. That said, the Supreme Court's conclusion that serious bodily harm includes psychological harm that substantially interferes with the health or well-being of the complainant signals that such harm can constitute harm that informs the criminal law. And we return to that issue later in the paper. But in any event, because sexual integrity is something that is already specifically recognized in the criminal law as worth protecting, which I will discuss momentarily, we find it an appropriate and accurate term, and also one that generally captures what is going on in these cases. The element of sexual integrity is important to understanding the process of objectification in these cases. Also relevant, though, is the accused's appropriation of that sexual integrity to his own ends. That is what objectifies the complainant, reducing her as a means to achieve some purpose or goal completely unrelated to her own aspirations, desires, or self-interest. The accused does not treat her as an equal, worthy of respect and entitled to choose how her personal information is shared with others. Instead, the accused instrumentalizes her, using her to achieve his own goals and sublimating her will to his. Another unifying element dramatically illustrated in the cases we reviewed is their gendered nature. Now, obviously, the use and misuse of technology is not a gender-specific activity, but the reported case law reveals an inescapable gender component. First, there is a decided gender imbalance in terms of perpetrators and victims, with females vastly more likely to be targets, I would say even more so than in actual sexual offenses against the person. Second, even absent that disparity, the circumstances in which these acts are committed will likely cause at least partially differentiated effects based on pre-existing disadvantage and vulnerability among different sets of victims, including on the basis of sex and gender. Now, we don't in any way mean to dismiss the trauma that can be inflicted upon any victim of such behavior, including men. But it does seem reasonable that the gender dynamics of sexual inequality overall is likely to be reflected in the impact of technologically facilitated humiliation, bullying, or revenge. In other words, the patterns of oppressing, silencing, and demeaning women that are endemic in a patriarchal culture reproduce themselves in these offenses, and is thus a proper consideration in framing an appropriate response. A final unifying element is that the use of technology, particularly when it involves the internet, has a uniquely damaging impact. The internet, of course, is iterative. It has a boundless capacity for reproduction, dissemination, and publicity. The consequences are correspondingly staggering for victims. Not only does the internet's sheer size and scope have severe limiting effects on any remedial measures, it can lead to extreme psychological harm and emotional suffering. The latter component of damage or harm might be thought to best explain why such activities should be a concern of the criminal law. It's easy to see how the near limitless reach of the internet multiplies the harm to one's reputation, social standing, future prospects, personal relationships, and even security. The sheer magnitude of the exposure can itself be understood as an aggravating factor, transforming what might ordinarily be understood as a private law harm, say defamation, to a criminal law one. And that reality is slowly being recognized by courts, including the Supreme Court. We don't contest that the harms that befall victims in these cases are diverse and profound. Nonetheless, we do not favor a harms-based analysis as the primary trigger and justification for the use of criminal law in this emerging area. For one thing, such an approach may lead to cases being minimized or ignored if proof of such harm is unavailable. For example, it may be difficult to show how many people received or opened a particular offending message. While there may be forensic evidence that records the number of clicks on a blog post or the number of times that a video is downloaded, such facts may be difficult to establish on the criminal standard of proof beyond a reasonable doubt. Or the Crown may simply not be in a position to obtain such evidence. Second, more importantly in our view, a harms-based approach misstates, or at the very least inadequately captures, the role of the criminal law in general and in these cases in particular. And that is, as we argue, a function that is in large part expressive. The criminal law serves to guide citizens away from and to express broader social disapprobation of certain conduct. The motivations for such guidance may rely on an apprehension of the harm of particular behavior, but it need not. What is a constant is that the criminal law power is harnessed against behavior that the state considers wrongful. It is that aspect of this behavior that we think more clearly justifies the application of criminal law sanctions. Another reason why a focus on risk, harm, and punishment is inadequate is that in a free and democratic society such as our own, the criminal law is necessarily under-inclusive. Canadian society cannot plausibly pursue the elimination of all harm, the mitigation of all risk, and the punishment of every person who breaches its limits. To do so would require a level of surveillance and enforcement that would conflict with other important norms, such as personal privacy and a zone of non-interference from law enforcement authorities. It would require essentially a police state that almost all citizens would find intolerable. Absolute enforcement would also require the removal of much discretion by criminal justice actors, such as police and Crown attorneys. Now, to be clear, there are legitimate concerns with such discretion and the opaque decision-making that can result. This problem is especially acute when trying to review individual exercises of Crown discretion. But removing all such discretion in the hopes of arriving at some kind of more perfect model of criminal law would be highly problematic. The second reason we think that a focus on wrongfulness is preferable is that the wrongfulness of such acts is not reliant upon their harm. It is instead based on something deeper, a link to what might be thought at first glance to be a quite separate set of offenses, sexual assault and its variants. So in other words, we think that this general class of offenses actually resembles in significant ways the existing criminal category of sexual wrongdoing against the person. Now, at its core, sexual assault is an offense concerned with preserving an essential feature of human well-being and autonomy, control over one's status and use as a sexual being. It is preoccupied with the importance of protecting sexual integrity, and just as with the offenses under discussion here, it is necessary to look beyond the frequent physical and psychological harms of sexual assault to recognize its true import for the criminal law. This is because while harm often does result from sexual assault, it is not the core of the offense. John Gardner and Stephen Shute have a famous thought experiment in which the victim of a sexual assault suffers no discernible physical or psychological injuries because she remains forever unaware that it ever happened. Does that lack of discernible injury have a bearing on criminal culpability? Gardner and Shute suggest, and this is a view with which we agree, that it does not. No right-thinking person would conclude that merely because of the lack of such discernible injury, the assailant engaged either in no wrongdoing or in wrongdoing that lies outside the scope of the criminal law. Now, it could be argued that the use of technology is inherently less intrusive on a complainant's sexual integrity than the direct non-consensual contact involved in sexual assault. The purported lack of immediacy or directness might seem to muddy attempts to draw a link between technological harassment or exploitation and the specific offense against the person represented by sexual assault. In effect, it could be argued we go too far in calling such behavior, reprehensible though it might be, violence. Or the term we adopt in this paper, technologically facilitated violence against women and girls. We have to come up with a really snappy acronym. I thought TFAW, but I don't know if that works. Too close to TFAWG. Now, it is interesting to note that when it defines offences, Canadian criminal law rarely uses the term violence. An exception would be, for example, the crime of intimidation. Although, as we discussed elsewhere in the paper, courts do sometimes, because they have to, define violence for the purpose of sentencing. The law does, though, clearly separate crimes that involve some interference with the physical person. That's undeniable. Nonetheless, the focus in recent years on the gravamen of sexual assault, while obviously concerned with sexual touching, reflects a wrong that goes deeper, we think, than that mere physical interference. The essence of sexual assault is objectification that is wrongful in a special way, a way that merits the imposition of criminal culpability, because while all forms of assault, while assault simpliciter supersedes an individual's physical and psychological integrity, sexual assault is particularly marked by what might be called the perpetrator's sheer use of the victim. Now, the intuition that when we sexually objectify people in certain ways, we do something wrong, not merely harmful, helps to explain the particular function for sexual assault of consent. Parliament, of course, has enacted a special set of rules unique to sexual offences that do not apply even to other forms of assault. The Supreme Court of Canada, too, has confirmed that sexual assault is not only about, in Justice Major's words, having control over who touches one's body and how. The court has adopted an approach to the fault element for sexual assault in which a defendant, for example, cannot rely on objectifying attitudes and beliefs to exclude mistakes about consent. In fact, the Supreme Court has said that such objectifying attitudes and beliefs actually constitute mistakes of law, not fact. That is why in Canada, proof of harm is not a precondition to a conviction for sexual assault simpliciter. And it explains the centrality of consent to the offense as part of both the actus reus and mens rea. Objectification occurs when one person uses another without taking into account or ignoring or being indifferent to that person's desires, aspirations, projects, and plans. In the sexual assault context, the risk of such objectification is deemed crucial enough to warrant a special duty to take steps to ascertain whether consent is present, should the accused later wish to rely on the defense of mistaken belief. Now, of course, the criminal sanction cannot and probably should not apply to all of the ways that people objectify one another. That would expand the criminal law in problematic ways, because objectification, of course, is a pervasive part of human interaction. It would also risk capturing much valuable behavior in which one person, for example, assumes responsibility and decision-making for another's welfare. But even if not all objectification can and should be addressed through criminal sanctions, the objectification at work in offenses like the non-consensual distribution of intimate images, for just an example of the cases that we looked at, is particularly troubling. The perpetrator acts either with the knowledge of the complainant's non-consent or recklessness to that possibility, and even the circumstances under which a defendant might credibly argue that he was under a mistaken belief that he had the victim's consent would seem to be very rare. It's difficult to imagine the circumstances that might support an argument that she was indifferent to or welcomed such dissemination, at least without slipping into familiar mythology that suggests if a woman consented before, for example, by herself posting a nude or semi-nude photo, she is more likely to have consented this time. And what I find interesting here is that the scope for such a category of argument around mistaken belief actually seems narrower on the facts than in most instances of sexual assault, because sexual assault at least involves the messy and unclear ways in which people communicate their sexual desires and expectations, and the unfortunate but pervasive human frailty of believing something to be true because one wishes that it was. Thus, we argue that technologically facilitated violence against women and girls is conceptually linked with criminal offenses against the person that recognize the wrongfulness of interfering with a person's sexual integrity. The legislative process undergirding the enactment of these offenses has not occurred in a neat or linear manner. The offenses were created at quite different times. They respond to different social mores. In some cases, offenses may need to be further updated or amended to better reflect the concern with wrongful objectification. But certainly for those offenses that have been enacted or amended in the last decade at least, we believe it appropriate to describe them as united by a focus to single out wrongful behavior regardless of the level or extent of harm suffered by the individual complainant. And it is entirely justifiable, not to mention analytically coherent, to view them as responding to a type of wrongdoing that is closely linked to sexual assault. For these reasons, we argue that criminal law both can and should be used to address this species of offenses, although, as we outline in the paper, the nature of that response varies widely in terms of doctrinal coherence and the attitudes of various actors in the justice system. Thank you.